Man, there is so much that has happened in this case because it's been going on since May 9th, 2022. And it's going to drag on even more because of how many witnesses there are, because it literally took 10 months to get a jury. And there have been so many delays, and it is a RICO case. So there are a lot of people who, a lot of defendants. Heard it might go on until 2026, and it's fucked up because Young Thug has been denied bond multiple times. So for the past 2 years, he has been in the Fulton County jail system. Fulton County Jail, which is in Atlanta and is notoriously one of the worst jails. There are multiple incarcerated folks who are just constantly dying because of the squalor conditions. It is inhumane. It is inhumane. And it's also famous because that's where Trump got his mugshot. And Fannie Willis, who is the DA, is the one who is prosecuting Trump's RICO case. So on May 9th, 2022, 28 suspected gang members were arrested in Buckhead as part of a 56-count indictment. Jeffrey Williams, a.k.a. Young Thug, was one of them. He has been accused of running a criminal racketeering ring. They are trying to nail him and those who work under his music label YSL as being part of a gang. And so they are trying to show that YSL is not a real record label, but is really just a front for this violent gang activity. And there's a lot more in between all this, but just a little briefing.
But I got something to do with that body. I got the streets on my back. Carry it like I'm moving the body.
All right, welcome back. That is Young Thug's Anybody, one of the songs containing lyrics that will be used against him as he faces charges of racketeering and gang conspiracy in a trial that started this week.
He's facing RICO charges in Fulton County, Georgia, one of 28 people charged in the case allegedly associated with a gang prosecutors say he founded. And joining us now with more is ABC News contributor and attorney Brian Buckmeyer and ABC News contributor and SiriusXM host Mike Muse. All right, so Young Thug has pleaded not guilty. He's denied all of these charges. Brian, what's he facing here?
If you're thinking about it from a jail time perspective, the top charges, that being the conspiracy to violate the RICO Act, which is basically saying 3 or more people conspiring to commit a crime, and at least one of those people takes steps towards the commission of that crime, as well as gang activity. Each one of those charges faces about 5 to 20 years, and you can stack those on top of each other. So for someone in their early 30s, that's all but a life sentence.
And Mike, Young Thug is a big deal in the world of rap. Could we see other high-profile artists take the stand in this case?
Yeah, you absolutely will see a lot of high-profile artists take the stand in this case, in particular thinking of Lil Wayne, but also too DeMarco and Evo. It's going to be about individuals outside the courtroom who won't be taking the stand, but will be taking a position on this stand on if hip-hop lyrics can be used in the courtroom or not. And we've already saw that happening with Kevin Liles doing their pre-trial arrangements, that he was very vocal, as well as Lear Cohen, another big music executive. So you're going to see music executive, music activists, and artists really voicing their opinions on this outside the courtroom, which would just as big as if they're inside the courtroom.
Brian, you know, Young Thug has waited a long time for this trial. We're already seeing crazy drama in the midst of it. What is going on here?
It's a lot. I mean, it took us 10 months just to get to the point of opening statements because of allegations of drugs being brought into the court. Attorneys were arrested for allegedly throwing cell phones as they were getting arrested for having pills in their bottle and assaulting officers. There's just so much drama that led to this point, but also it's just the nature of the case. You try to prosecute 28 people at once for RICO RICO charges with 191 overt acts. I mean, it's a lot. I mean, thankfully, we're down to 6 defendants in this trial and 9 taking a plea, but it's a lot to kind of wrap your head around and also a lot to get started.
Yeah, legal scholars are saying that this is one of the most complex RICO cases in history. They expect it to continue on for years because of the number of witnesses that the state plans to call up. It has also been just inundated with so much drama. Like the type of shit that you would think happens only in a television show. For instance, there was something that happened which is fucking crazy. And what happened was when they began proceedings for the trial, and they had they were having technical difficulties at the courthouse, and so it had delayed. I think this was last week. They had delayed the motions hearing for hours. And once the proceedings began, someone on Zoom, because this was over Zoom, someone on Zoom barged in with full frontal nudity. It was a pornographic video of a completely nude man shown on screens throughout the courtroom with the message, "Free Young Thug." Deputies scrambled to turn off the screens as the judge insisted on decorum in the courtroom. Like, this is the type of shit that's been happening. The county's IT staff set up a new Zoom link for the attorneys watching remotely, and officials later determined someone on the Zoom call shared their screen showing the nude images. So that's one example. Another example of just insanity that has inundated this trial is there were jurors who were accidentally shown, who were accidentally on the live stream because the trial is being live streamed. There were screenshots of 3 or 4 jurors seated in the front row that was captured on the live stream and shared widely online. In the clip, the faces of at least 2 members of the panel could be seen. A photo of the jurors was showed on social media by a pop culture podcaster with 1.3 million followers. The judge said, due to some security issues and the fact that we have an inadvertent recording of some of our jurors on the front row, would it be appropriate or okay if you all would not continue to film Detective Mark Belknap? Glanville asked several reporters in the courtroom. Glanville said the journalist could continue to record audio of the detective's testimony, but asked that his face not be shown. Yeah. So just a lot of crazy shit.
And Mike, Fulton County District Attorney Fani Willis said publicly, and I want to quote her, "I think if you decide to admit your crimes over a beat, I'm going to use it." Rap is and has always been a creative way of art. How will this impact, the game moving forward?
Honestly, it's unconstitutional. If you're going to display your, display your crimes over a beat, then I'm going to use it. That is strangling freedom of expression. And that is one of the arguments at the heart of this trial and how this trial could affect the hip hop industry. And rightfully so, legal scholars and other people who have been involved in just discussing this trial for the past 2 years are talking about how it's not the first time that lyrics have been used as evidence against hip hop artists, but that this doesn't happen to white musicians. When Johnny Cash said, I shot a man in Reno just to watch him die, that wasn't used as evidence of him committing a crime. And so using lyrics in hip hop and rap as evidence of admission to crimes that have been committed is the problem that's at the center of this case.
I would start where you ended, DeMarco, in the sense of rap is a form of art. My concern is when they admit too many lyrics into the courtroom and trying to prove that case. Admitting too many lyrics and too many songs could really bias a jury if they're not understanding of culture, the culture of rap, and the culture and communities from where these artists come from. Now, with that being said, if an artist says they committed a crime on a certain intersection of a street, and then that is in their lyrics, then that is fair play for that lyric to be used. But the idea of supporting in totality, inserting songs and other lyrics trying to support a case, that is what I take issue with, and a lot of activists take issues with too as well, because rap is also too a form of literature in a sense of allegories, alliterations, and metaphors.
But Mike, strong talk is nothing new. I mean, you and I have talked about it. Tupac's Hit 'Em Up. That's a strong song there. And when you look back, you're like, whoa, if it was in today's, time and place, it would have been used against him in court.
You see me smiling so big right now because, DeMarco, you nailed it. Even to the point now where in the very popular lexicon of culture, we use the phrase gang, gang. Gang, gang doesn't mean the actual gang unto itself, what we know formally as a gang, but gang, gang culture means just family, a clique, your homies. And so that's what I mean by if the jurors are not aware of culture, they could use these words in the literal sense and not understand that they have many different double, triple entendres.
Well, let's look at the legal part of this here, Brian. How common is it to bring lyrics into a case?
It's very common. I've even defended clients who have this situation themselves, and I'm often telling my clients, hey, if you're going to rap on a beat, you got to treat it like you're in an interrogation room, because ultimately these charges could be, these lyrics can be used to incriminate you, to incarcerate you, and even for sentencing enhancement at the end of the day. And I don't think necessarily this is going to create a precedence, because the precedent's already there. I think the general fear that people...
When you create a rap, you need to act like you're in an interrogation room. That's crazy, my guy. That is not something that should be the case here, or that shouldn't be the standard here.
Or the worry that people should have is when we give prosecutors an extra tool to prosecute and to limit the liberty of a sect of people, we have to make sure that prosecutors are doing that correctly and not overly broad, because if we give them power to go after one group, who's next on that
thank
line?
You for the 12
and is
months.
it done properly and effectively? I think that's why this case is so important.
And Mike, real quick, you got a background in music. Do you think rappers will start to say, okay, you know what, I may want to think about what I'm going to say on this next track before I release it, or is this empowering them to do more?
I think they're going to think about what they rap about, but DeMarco, that really begins to infringe on their First Amendment rights and their First Amendment right to be creative and as a form, an art form, as expression. Who are we as society to govern and to dictate what is art and what isn't art just because we may not like it? As Brian perfectly illuminated, that there is precedence for lyrics to already be used, but the nature of this case is different because Young Thug is such an influential artist within the rap community as a whole. So in essence, this is the first time that rap lyrics is on trial with such a very popular artist.
All right, ABC contributors Brian Buckmeyer and Mike Muse. Good to see you guys, and thanks for being on, as always.
Okay, let's watch here.
Well, there's controversy brewing in Atlanta over the prosecution's tactics in the racketeering trial of a popular rapper. Young Thug, whose real name is Jeffrey Williams, is accused of leading a violent street gang, and prosecutors are trying to use his lyrics against him, a practice condemned by many legal experts and by other musicians. Jerika Duncan is following this trial. Jerika, good morning.
Good morning to you. You know, there were 6 co-defendants that are still a part of this trial, a host of witnesses that will be called, the prosecutors trying to prove that YSL is a gang and it committed crimes.
Jeffrey Williams, the Grammy-winning rapper known as Young Thug, sat in a Fulton County courtroom Monday listening as prosecutors made opening statements against him.
As you will see throughout this trial, stolen handguns will become a reoccurring theme.
Williams is one of 6 defendants standing trial in Atlanta. They are accused of being members of the street gang Young Slime Life.
Murder, armed robbery, aggravated assault,
including the drive-by killing of rival gang member Donovan Thomas Jr. in 2015. While Williams is not charged in Thomas's murder, prosecutors say Williams helped arrange it by renting the car used in the killing while paying cash to those involved and giving them instructions to, quote, lay low. What followed, prosecutors say, was a wave of racketeering and other crimes. The prosecution says Williams sits atop a criminal enterprise and through his music as Young Thug promoted and glorified the gang's alleged crimes. Prosecutors say this lyric from the song Anybody is evidence.
I never killed anybody, but I got something to do with that body.
He's not using gang colloquially. The evidence will show.
So, in addition to using lyrics, they combed through social media and any instances of gang signs, anything that had to do with clothing, like any apparel that seems connected to gang stuff. They're using this all as evidence.
He's telling you they are a gang.
Attorneys' use of lyrics as evidence in court has come under scrutiny. Last year, dozens of record labels and more than 100 artists, including Alicia Keys, Coldplay, and Ice-T, signed a letter stating rap lyrics should not be used as evidence, noting prosecutors are using artists' creative expression against them.
Rap music is the only fictional form, musical or otherwise, that is targeted like this in the courts.
Eric Nelson is the co-author of the book Rap on Trial.
Not only do prosecutors
I like that this is the whitest guy who has written a book that he's super based on this, where he is obviously an expert on how rap is the only music that is used for trial purposes for prosecution.
cherry pick lyrics and decontextualize them to serve their own purposes, but they often do it without any knowledge or understanding of rap music at all.
Now, if convicted, Williams could spend up to more than 20 years in prison. All 6 defendants, including Williams, denied the allegations. And I think it's important to note, Anne-Marie, that while there's been so much focus on these lyrics, the prosecutor in her opening statement said, quote, "We didn't chase any lyrics to solve murders. Authorities chased murderers and found lyrics."
What is she trying to? Is she trying to like create a rap here too? Is she getting all lyrical with it?
Okay, that's a good point, but I think that it is part of the sort of public interest in this trial is the fact that the rap lyrics were included as evidence.
Yeah.
So I just want to explore it a little
Oxy?
bit more. And, you know, I'm wondering about what the counter argument will be. I mean, could they be claiming, listen, this is freedom of expression, artistic expression. This is what people do. It doesn't necessarily mean that they're living the lyrics.
You know, Skylar Henry really zoned in on this through America in Black, which is a series that BET and CBS are part of. And he looked at this issue, and what he found is that there have been at least 500 cases in the 90s, since the early 90s, that have been used as evidence in more than 500 criminal cases. With this particular rapper, who's well known and has performed with many artists, was even on the soundtrack with Camila Cabello, Havana. I think I'm saying it correctly. But is well known, has been rapping for 10, 15 years now. And I think that this is a moment in time where people are asking, well, if I say these words, could they be used against me in the court of law? And right now, prosecutors, again, are saying essentially this is something that supports other evidence that we have. We didn't just focus on these lyrics alone. But as you heard a little bit from that prosecutor in her opening statements, there are lyrics that they're saying connect this person with specificity to specific crimes that they are alleging he was connected to.
I remember hearing about this trial. I mean, a while ago, you talked about Skylar Henry's story. That was in the summertime, and then suddenly it was all Donald Trump and his trial. So why has this taken so long to kind of get going?
Because you're talking about 26 people in the beginning, and now we're down to 6. And this is a process in terms of getting jurors. It took 10 months just to get the jurors to sit for this trial. So when you have a number of these co-defendants, a number of people, you're talking about an enterprise, right? An organization of people that they are trying to connect the dots. So for instance, there's another rapper named Gunna who did plead guilty to one charge. He is not expected to testify against Williams, but they were close at one point. They rapped on different albums and songs together. So I think it's the idea of having so many people involved trying to prove that they are connected to YSL, which some, again, are calling a gang. Others are saying, no, this was just a record label. We weren't into any mischievous crimes, as the prosecution is saying. But it will be interesting to hear how the defense will respond to, as she said, Williams's own words and actions.
Yeah, it will be interesting. Jerika, thank you very much.
Rapper Young Thug's attorney will have.
Okay, so Gunna, I want to explain the Alford plea that Gunna took. So Gunna was released in 2022 from the Fulton County Jail after pleading guilty to his part of a sweeping gang indictment that also includes rapper Young Thug. But he entered a negotiated plea known as an Alford plea. An Alford plea allows a defendant to maintain their innocence, but acknowledge that pleading guilty is in their best interest. So this caused a backlash because a lot of people who have been following the case felt like he shouldn't have even done that. If a defendant chooses to enter an Alford plea, prosecutors must still provide all the evidence to support the defendant being guilty. But it was a way for him to get out of jail while this is ongoing. He was sentenced to 5 years. He was facing one count of violation of Racketeer Influence and Corruption Act. Was sentenced to 5 years with one served in prison. The 1 year sentence was commuted to time served. The 4 year remaining balance on his sentence has been suspended and will be subject to special conditions, including 500 hours of community service. After the sentence came down, he released a statement saying, "While I've agreed to always be truthful, I want to make it perfectly clear that I have not made any statements, have not been interviewed, have not cooperated, have not agreed to testify or be a witness for or against any party in the case, and have absolutely no intention of being involved in the trial process in any way." So that's just a little context there for what they were talking about. Okay, next up, let's watch.
Rapper Young Thug's attorney will have to report to jail.
Okay, so before we get to what happened today, let's take a look at this article here, because today was pretty crazy. Let's see, do I want to look at the Vulture article or this Washington Post one? Okay. All right, I'm going to start here. Young Thug's rise in the 2010s loosely coincided with increasing public concern about violent crime in Atlanta, which calls for authorities to take major action. Prosecutors under District Attorney Fani Willis set their sights on Young Thug and about 24 others believed to be associated with him. Investigators searched social media posts for gang signs and came to believe that some of Thug's lyrics about crimes and shootings were based in reality. Thug was one of 28 people arrested in raids across the city on May 9th, 2022. An 88-page indictment lays out the government's case that they operated as a gang called Young Slime Life, which prosecutors noted bore the same initials as his music label, Young Stoner Life. The members and associates of YSL moved like a pack, with defendant Jeffrey Williams as its head, lead prosecutor Adrian Love said during opening statements at the trial. Specifically, Thug was accused of renting a car used in the fatal 2015 drive-by that led to a gang war between two blood sets. But he was accused of involvement in a long list of homicides, armed robberies, aggravated assaults, theft, drug dealing, carjacking, and witness intimidation that his co-defendants are charged with. Thug's attorney, Brian Steele, denies the charges against his client, who pleaded not guilty. The prosecution has taken a young man who was born into no opportunity, despair, and hardship, and he has become a world-renowned, award-winning musical artist. Thug has essentially lived behind bars since his arrest, barring infrequent excursions such as a trip to his sister's funeral last year. He's driven 20 miles from his jail cell to the courthouse every weekday morning to bear silent witness to one of the most complex racketeering cases in Georgia's history. Legal experts told the Post that it's unconventional that Thug and his co-defendants are being prosecuted under Georgia's Racketeer Influenced and Corruption Organizations Act, aka RICO, which is a legal framework prominently used in the 1980s to punish mafia activity. Famously, this is what took down John Gotti, and which Willis and her prosecutors will also use to try former President Donald Trump on election fraud charges this summer. RICO laws allow prosecutors to dismantle entire criminal organizations from the street level to the top. If convicted, Thug and his 5 remaining co-defendants, the others either cut plea deals or will be tried separately, could face up to 2 decades in prison. But RICO cases are also notoriously massive, complicated, and unwieldy, creating opportunity for disruptions and delays, all on ample display during this case's long windup. Okay, and then this is this is another example of craziness during this trial. The scream startled everyone. It was April 19th, 2023, midway through the case's year-long jury selection process that sifted through more than 2,000 potential people. Thug's head shot up and some of his co-defendants leapt to their feet as Rodalius Ryan, an alleged member of Thug's crew already serving life in prison for a 2015 murder, cried for help from a cell down a hallway from the courtroom.
First, we start with breaking news. So in the last 30 minutes, here's what we know. Officials cleared the courtroom after commotion during the YSL trial. So this all happened with the rapper Young Thug sitting in the courtroom. So listen carefully to this audio so you can hear some type of screaming in the background. All right, so screaming, some sort of moaning. You see the activity here. You can hear the screams. About 90 seconds later, saw court officials restraining somebody, taking that person out. Seconds after that, they cleared the entire courtroom. So they're in recess right now. It's 5 o'clock. We have a Channel 2 Action News reporter and photographer at court right now. We're working to learn what even led up to the events you're seeing right here on your screen, and we'll bring it to you as soon as we get those updates.
Okay, so that happened April of 2023. Footage of the incident showing deputies almost losing control of the room. Cordarius Dorsey, another co-defendant, tried to barge past deputies at the door in an apparent attempt to reach Ryan. Max Shart, who was representing Shannon Stillwell, implored the room with outstretched arms. Everybody just chill. It was later reported that Ryan was screaming as deputies strip searched him. They allegedly found 2 packages of marijuana sewn into his underwear, according to body camera footage aired on local news. On most days, the courtroom is kept under control. So essentially, so much craziness has happened in this courtroom because this courtroom, this Fulton County Court, is not equipped to handle a case of this size and of this complexity. Permission to hit the bong, Big C? Permission granted. There was also a deputy who had, I don't know if this is the same thing, but a deputy who had snuck in drugs. That happened. Let me read up here because they have. So we had the pornographic Zoom bombing. Jurors' faces accidentally live streamed. One of the co-defendants accused of a hand-to-hand drug swap in full view of the judge. A deputy arrested for allegedly smuggling contraband into jail and having an inappropriate relationship with another co-defendant who has since been severed from the case. When a potential juror skipped court to visit the Dominican Republic last year, Judge Glanville ordered them to write a 30-page essay in APA style with primary and secondary sources. So one of the reasons why took a really long time to get the jury together on this is because of how long this trial was expected to be. Not everybody can take all that time off of work or take all that time off from their lives. That is a huge, huge commitment. When a juror asked for the courtroom to be made warmer, Judge Glanville replied that he kept it cold to keep everyone awake. The judge told an attorney who showed up late to a hearing in May that he would be held in contempt unless he bought everyone lunch. This judge is sketchy as hell, y'all. And as Glanville grew frustrated with the trial's plodding pace, prosecutors by mid-April had so far only made it about a quarter of through about a quarter of more than 200 expected witnesses. He has threatened to hold court on the weekends. But the surreality of the case sometimes gets away from the judge. Glanville inadvertently went viral on social media in the trial's first week for reading out Young Thug's lyrics in his monotone drawl. Why is this not loading? Shit. I want the link. Why? What? Maybe I have it saved in here. Hold on. I hate when things don't link. Oh, there we go.
That pistol on my hip, you praying that you live, I'm praying that I hit, hey, this that slime shit. Fuck the police, fuck them in a high speed, 100 rounds in a Tahoe, I'm prepared to take them down, got banana clips for all these niggas acting monkey, this that slime shit, this that mob shit, fuck the judge, YSL. And I got that pistol on my hip.
I'm sure he took that part personally. Fuck the judge. Yeah, this is ridiculous. His flow was kind of whack, though, not gonna lie. God. Okay, so other incidents have been, like, this stuff is obviously humorous because it's ridiculous. It's ridiculous to hear this judge reading these lyrics out loud. Other incidents have been more serious. A video of a defendant's interrogation was leaked online last year, sparking an investigation. The Fulton County, so this is the story. Fulton County judge presiding over the sweeping Young Slime Life gang case is ordering an investigation after a leaked interrogation video was posted online and viewed millions of times. Judge Glanville also reminded defense attorneys and prosecutors of their obligations to keep certain evidence confidential ahead of the high-profile trial. It affects everyone's right to a fair trial, the judge told attorneys Wednesday. I don't know who did this, but if this pertains to you, please amend your ways. You're playing a very dangerous game with your 6-digit bar number. This is such a mess. Such a mess. Katie, thank you for that, gifted. Wednesday's hearing came 2 weeks after the release of a video showing a 2021 interview in which a state's witness offers to provide information in the years-long investigation of Atlanta rapper Young Thug in exchange for leniency. Defense attorney Gina Bernard, who represents defendant Jaden Rick, recently filed a motion seeking a mistrial. While said evidence may not directly implicate my client, it, along with all of the publicity and courtroom incidents since the start of this trial, make it impossible for him to receive a fair trial, as well as a jury that's honestly and truly fair and impartial. In their response, Fulton prosecutors accused the defense of leaking the video, arguing that it was posted online less than a month after being turned over as discovery. The state has absolutely no interest in leaking this video to members of the public, as its dissemination serves only to intimidate and harass witnesses called upon by the state to testify in a very serious and high-profile case, prosecutors wrote in their response. The DA's office said the leaked video puts their cooperating witness in danger, and included several screenshots of social media posts labeling the man as a rat and a snitch. The judge says he doesn't know who's responsible for it. He denied Bernard's motion for a mistrial, but instructed both sides to be more cautious about how they share discovery evidence going forward. For me to have to deal with this at this point in this trial is unacceptable. Okay, wait till we get to what happened today. As a result of the leaked evidence, prosecutors have asked that the judge further restrict access to certain discovery in the case. They said that if the leaks continue, they would request that certain material only be made available inside the DA's office on the 3rd floor of the courthouse. Glanville warned attorneys that if more evidence is leaked, he will restrict them to only reviewing discovery in his chambers. Defense attorneys pushed back against the state's allegations that they're responsible for the leaks, saying their clients have the right to review as much evidence as possible ahead of trial. Suri Jimenez, who represents Cordarius Dorsey, said the video could have been obtained and leaked by anyone because prosecutors have been sharing evidence through an unsecured Dropbox link. Several attorneys also accused the prosecution of not turning over its evidence in a timely manner, which they said hinders their ability to defend their clients. Holy shit. Okay. So that happened. A defense attorney in the trial was arrested on charges of bringing prescription pills into the courthouse and allegedly throwing his cell phone at a deputy's head. A potential juror was briefly jailed for recording court proceedings. Less than a month of the start of the long-anticipated trial in December, Glanville paused proceedings for several weeks after Stillwell was stabbed in the Fulton County Jail. Prosecutors have been using rap lyrics as evidence since at least the 1990s, with mixed success and despite criticism that white musicians are rarely accused of doing the things that they shot about. Using the example of Johnny Cash not being charged for saying he shot a man in Reno, just to watch him die. I think we should all be uneasy when forms of artistic expression are taken as literal truths, almost as public confession. There's a real slippery slope, said Anthony Michael Crease, a law professor at Georgia State University. Asked for comment, the DA's office pointed to the judge's November 2023 ruling that the lyric and related social media evidence is logically and legally relevant and thus conditionally admitted. The trial is a sensation online with thousands of comments under a live stream from the courtroom and entertainment sites covering every legal argument and cultural repercussion. Chance the Rapper's birthday wish is for Young Thug to be released from jail, reads a BET headline Wednesday. In Atlanta, where rap is a multi-billion-dollar industry, up-and-coming artists have also had a wary eye on the trial. They're looking at DA Fonnie Willis like she's turned Atlanta into Gotham, said musician Langston Blue. It's not cool to be guilty of something just because you're really good at selling that. Atlanta musician Cade Fortunat, who sings under the name Fortunat, found it laughable that lyrics could be considered evidence. When a rapper puts the word Glock or AK-47 into a track, he said, they are more likely to be considering the syllabic structure of the word than remembering a real event. Z6 Saint, native Atlantean and rapper, noted Young Thug's imprisonment has not drawn many public protests. He's been denied bond 3 times and has served nearly 2 years in jail. In Fulton County Jail, which is just a barbaric place. But he worries what will happen to the next generation of rappers if Thug and others are muzzled. So this is what we refer to as the chilling effect. We talk about this often with sexual assault cases. So whenever a powerful individual is on trial as a defendant in a sexual assault case and the burden of proof is not met, and so they are acquitted, it then results in a chilling effect where other victims of sexual assault who were considering coming forward decide not to because they see the consequences there. And so same here, if Young Thug, if things go south here, if Young Thug's lyrics, which are being used right now in the trial, are assist in putting him away, then it's going to create a chilling effect on future hip hop and rap artists. But he worries what will happen to the next generation of rappers if Thug and others are muzzled. I don't think people are too worried about it. He said they probably should be more worried about it. If Thug has been chilled, it's not readily apparent. He released a new album, Business is Business, in June 2023, illustrated with an image of himself at the defense table beneath an empty judge's bench. Okay, so let's talk about what happened today. So,
All right, what is already being called the wildest trial in hip-hop history just took another twist. Rapper Jeffrey Lamar Williams, also known as Young Thug, is at the center of a racketeering trial. And now his lawyer is caught up in his own legal battle. So just yesterday, the lawyer was arrested during the trial and charged with contempt of court. So joining me now is legal reporter Megan Cuniff. Welcome back to the stream, Megan. Thank you so much for being here.
Thanks for having me.
Okay, so can you walk us through exactly what led to the judge holding attorney Brian Steele in contempt of court just yesterday?
Yes, so this arrest on Monday actually stems back to what happened on Friday with a key prosecution witness named Kenneth Copeland. He is central to the prosecution's case and was set to take the witness stand, but he was all of a sudden reluctant on the stand. He had a lawyer with him that morning who said he wouldn't be testifying. There was some back and forth. He eventually got on the stand and invoked his Fifth Amendment right against self-incrimination in a very defiant way. It wasn't a proper use of the Fifth. It was when he was asked his age, and he'd already been granted immunity by prosecutors. So the judge actually held him in contempt of court and said, and made him go to jail over the weekend and said, you're going to be in jail until we get your testimony. And that was when the prosecutors raised concerns about what the defense attorneys were doing with Woody's lawyer. This is the witness. Kenneth Copeland's nickname is Woody. And prosecutors had said that they were wondering if Copeland's lawyer was really working in his best interest or if he was working to block Copeland's testimony on behalf of the YSL defendants. I think that gives context for why the judge felt it was okay for him to do what is widely considered a really unusual and by a lot of people improper meeting that he had privately in chambers with prosecutors and the witness, and defense attorneys weren't privileged to that. This was ex-parte communication that he acknowledged, and there was actually a court reporter there, so there's a transcript of this somewhere, but he made the point to Steele's lawyer that he doesn't think that Steele had a right to be there, and he really wanted to know who told Steele about this meeting. It was not the judge who disclosed the meeting. Steele is the one who confronted him about it in court and asked him about it, and that is what led to the judge really pressing Steele for who told you about this meeting, and that's what led to the contempt arrest.
Got it. There's a lot to unpack there. How will all of this potentially derail?
This judge should have been removed a long time ago. I just feel like I feel like the way that the judge has behaved is ranging from inappropriate to potentially illegal. So to reiterate, what happened here is that Steele, who is Young Thug's defense attorney, opened up in court by saying that he had been told of a meeting in the judge's chambers that morning between an important state witness and that witness's attorney, as well as Judge Glanville, a court reporter, and prosecutors. But obviously this is a big deal because Steele is saying, like, we were not informed of this meeting. You all had this meeting, which points to your sympathies for the prosecution, which Steele has accused Judge Glanville of previously throughout this trial.
The trial. I mean, the trial obviously already has a lot of drama, including this embedded within it. But could this derail it potentially even more?
No, the judge has made clear, pretty obvious, that he's not going to call a mistrial unless he absolutely has to, and that the jury pool drops below 12, which we're not at that
Megan,
point
I'm so
yet.
sorry. We have to cut
the
you
judge
off.
has rejected any calls for a mistrial and said
Keep
that
going, Megan.
Megan, I'm so sorry we had to cut you off, but we are tossing it over to a special report from CBS News on the verdict in Hunter Biden's gun trial.
Wow. Shut the fuck up, Megan. Moonflora, thank you for the 11 months. Okay, let's watch this from when it occurred.
I have a.
He's right behind you.
Sorry, I have a motion that I need to make outside the presence of Mr. Copeland.
All right, you can make it right now. Is he out?
Let me know when you get down to the.
Is Mr. Copeland out?
No, he's upstairs.
Okay, good. All right.
Yeah, come on now. Don't come in the court. Come and get your license.
Thank you.
Go ahead.
The way I understand my constitutional obligations, pursuant to the 6th and 14th Amendments of the United States Constitution, the corresponding sections of the Georgia Constitution, I'm required to make a full and complete statement to the court. For the record, and if God forbid this goes up on appeal for the appellate courts or another tribunal, commission, or administrative body, I was told, based upon information and belief, that when we arrived at 8:30, 9 o'clock today, we did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland
Important
and
context,
his
this judge
counsel
is a former military court judge.
met together. None of the defense team, to my
Seems like a
knowledge, was aware that this was
asshole.
going on. It was told, based upon information and belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information and belief, that Adrian Love, the lawyer for Mr. Copeland, and this court were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd to me. That never...
Mr. Steele, can I interrupt you just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too. And the reason
I'm asking you
Well, I'm disturbed too.
a question.
And I'm
How
gonna
did you
answer
find
your
out
question.
about it?
I'm going to answer you the question.
Okay.
Scuttle, if you look at SCUDDER versus state, which is 298 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somewhat accurate based upon what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me, and you and Mr. Adams meet with me, and others have met with me. It's those were ex parte for a lot of different other reasons, but I will certainly note that for purposes of record.
Well,
Okay, so a little, I think what was going on with this witness, this was a star witness for, this is a star witness for the state. They refused to testify. They were thrown into jail for the weekend and then had a change of heart. And it turns out that this closed door meeting happened between Judge Glanville, the prosecutors, this uncooperative star witness, and the star witness's lawyer. Steele found out about it. He refuses to cite his source as to how he found out about this meeting that took place, an improper secret meeting, which led to the witness changing their tune. Because remember, the witness refused to testify, was thrown in jail for the weekend, secret meeting happens, and then suddenly the witness changes their mind. An explainer on this exchange. Okay. What?
Take Mr. Steele into custody, please.
Every attorney with a pulse and access to Twitter, including me.
Let me actually finish this first, and then we can watch the explainer.
Going forward, what I was told was that Mr. Copeland said...
And you haven't answered my question yet.
I'm not going to answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to get anybody else.
I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based upon information.
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have this. I have problems right now.
Okay, I know. Look, I don't want to know about your problems, okay, at this point in time. All I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed,
the record's going to be available for our
The witness was given immunity and then pled the fifth, which led to the contempt. Okay.
court, and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with a party.
But I feel like that's not the real issue here. Like, the judge is making this about how did you get this information rather than the fact that this meeting took place. Like, that's what seems to be the real problem here. Man, I don't know why, but Steele is kind of giving me Saul Goodman vibes.
I mean,
a witness who was sworn in Friday, the court's telling, this is what I was told. If this is not true, not true. This court handed Mr. Copeland.
Tell me how you
perjury.
got the information.
Listen, whatever you want to do.
Tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it proprietary?
Or information that you should not be having that was ex parte.
Why?
With a party.
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court, or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele,
So what this could do is it could open the judge up to motions to recuse himself from both the contempt issue and then the broader case here. It can also be grounds for an appeal by Young Thug and his co-defendants if they are convicted. Like, it's wild. It's wild to see this case, of which I've just tuned into, but already am aware of the dramatics, the like Law and Order, Dick Wolf type dramatics happening in this trial, and how this judge is so very clearly should not continue as the judge in this case.
I don't want to know, how did you come upon this information? Who told you?
What I want to know is, why wasn't I there? Why,
sir? I'm going to hold you in contempt if you don't tell me who tell me who this information was
come from. I don't want to be
from.
held in contempt.
Well,
I'm not answering that question. That's attorney-client privilege information. I am not answering
attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out.
I am telling
I tell you what, I'm going to give you 5 minutes. If you don't tell me
you don't have to.
If you don't tell me who it is, I'm going to put you in, I'm going to put you in contempt, because that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information supposedly from my chamber?
Okay, the other thing is in emergency situations, a judge may meet with one side or the other. This is what is known as ex parte. But the judge is typically required to tell the other side that the meeting took place as soon as possible, which Judge Glanville did not do.
Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Well, I don't need it. I want to continue.
Look at
this is what I was told.
Judge.
Mr. Copeland made statements
that
he admitted to killing Donovan Thomas and was. Don't take my notes. No.
He literally just gets up and goes. He goes when the lawyer goes, you should have been the one to tell me. Why are you pressing me on who told me? You should have told me that this meeting took place and you did not, which creates grounds for my client to, for us to argue that my client has been deprived from a fair trial when this is what took place. Are you a lawyer? No, I'm not a lawyer. I did take the LSAT, but no, I just do research whenever I cover stories like this so I can understand and give you guys context.
He's right behind you.
Sorry. I have a motion that I need to make outside the presence.
This is wild.
All right, you can make it right now. Is he out?
Let me know when you get down to the
Is Mr. Copeland out?
No, he's a fan.
Okay, good. All right.
The prosecutors are also at fault for sneakily having these meetings without notifying the defense. Yes, but prosecutors and defense, like, they're going to do what they can. They're going to push the limit to get an advantage over the other side. This falls on the judge, who is not supposed to be on a side here and not supposed to be showing favor to, explicitly showing favor to his side. Like, of course the prosecutors are going to do whatever they can without the defense knowing.
Yeah, come on now. Don't come in the court. We'll come and get you that.
Thank you.
Go ahead.
The way I understand my constitutional obligations, pursuant to the 6th and 14th Amendments of the United States Constitution, the corresponding sections of the Georgia Constitution, I'm required to make a full and complete statement to the court. For the record, and if God forbid this goes up on appeal for the appellate courts or another tribunal, commission, or administrative body, I was told, based upon information and belief,
I think it's
that when we arrived at 8:30, 9 o'clock today, we did not come into your courtroom until almost 11:30.
I think it's
And what I found out
was a lot of different information in regard
not testifying
privilege unless you were in my chambers. That's the only way you can. How did you get that information supposedly from my chambers? Did somebody tell you?
Continue.
Okay, all right. That looped. Now, let's watch. Where is... I thought I had the video of him asking to be jailed with Young Thug. Do I have that?
Note that for purposes.
How did you be admitted to killing Donovan Thomas and was Thomas?
Okay, that's the end of that clip. I thought I had...
Rapper Young Thug's attorney will have to report to jail.
So Young Thug's attorney, Steele, once he was sentenced to, I think it's 10 weekends. Hold on. 10 weekends in jail. He's ordered to serve 10 weekends in jail, Fulton County Jail. And he has requested to serve next to Young Thug. Yeah. So all of these people online now are like tweeting out their support of Steele. All these Young Thug fans are tweeting out their support of Steele and saying that that's a homie who's, he's a ride or die criminal defense attorney who's going to jail for 10 weekends in a row and wants to serve next to his client.
Jail this weekend after he was taken into custody and charged with contempt of court. The fiery moment between Brian Steele and the judge is actually going viral now after Steele refused to answer how he heard about a secret meeting between prosecutors, the judge, and a key witness in the YSL trial. Now Steele will have to serve 10 weekends in jail and is requesting to do so in Cobb County with his client, Young Thug. I want to bring in ABC legal contributor Brian Buckmeyer for more on this. Brian,
this is the part after recess. Let me see.
Okay, Mr. Steele, would you take the podium, please, sir?
Also, this is considered pretty extraordinary to have a judge jail a lawyer for doing his job. And the legal rationale behind it being pretty complicated because the legal rationale is that he's refusing to tell a judge who his source is, but that's not really what's at the center here. It's that the judge First of all, it's that the defense was not included in the secret meeting in the first place, but that the judge did not notify the defense as soon as possible, and so the defense found out through a third party.
All right. All right. Mr. Steele, before I recessed, I asked you, how did you get this information? And it is not covered by work product. There's only one way you could have gotten it. So I'm going to ask you again.
And I respect that. And it gives me no joy, but as you know, Georgia Rule of Professional Conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have. 1.6.
I know what the rule says, but here's the thing.
Well, let me just.
You need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet.
He's so out of breath.
I need you to tell.
He's so out of breath. I feel like he got up, went into his little room here, and just angrily huffed.
Tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt.
I understand. I don't want to be held in contempt.
And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers.
I feel like he was yelling at someone too.
Parroted to you and others. It is that serious.
Yeah. And that's why I raised it. It is that serious that we should have been there and it shouldn't have happened.
Sir, that's a whole separate issue. And that's why ex parte conversations are recorded.
Why would it be ex parte? You're acting like it's ex parte under seal.
It's ex parte. It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
I've never asked this honorable court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not.
The issue is how did you get this information?
I understand the issue. I promise you. I
He's
understand.
so mad.
But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law.
You cannot you can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get the information?
But just listen to what I'm trying to tell you. You're threatening me with contempt.
The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you. I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to
the lawyer Steele is like, I ain't no snitch.
All information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe. You're asking me, I'm not saying you're ordering me, but to give you information, and you're saying it's not substance, but I'm telling you I can't do that under the bar rule.
All right, well, I'm going to hold you in contempt. And you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
I can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
I have an idea how you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time. And I'm not going to breach that confidence.
I don't want to hold you in contempt, but this is that serious.
Judge,
you cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
Judge, listen, and listen, I'll do whatever you want. To 5 o'clock.
Essentially, he's saying, too, that this information was not meant for the defense to hear. Like, that is so clearly indicative of an unbalanced trial, of an unbalanced judge, of an unbalanced trial.
Clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing, and I'm moving for a mistrial. It is my understanding, based upon information belief,
from whom?
Part of it.
From whom?
Well, I'd like to get the substance first, and then we can.
Okay, well, then you'll be in custody until then, because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
but you're assuming something because I told you already.
Well, then, other than if you were sitting, unless you were sitting in there with a recorder, or Miss Love, or Miss Hilton, or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor.
And if that person gave you that information, or shared that information with you, she probably violated privilege.
Well, let me tell you two things. One, I don't know how that was a privileged communication. It shouldn't have been.
Well, it's because she has a client she's supposed to represent.
Who are you talking
But
about?
anyways, I'm not going to have a...
By the way, the witness is Lil Woody, and this is what I had talked about previously, where an interrogation video of a witness was leaked online, and it's just a shitstorm from that. So Lil Woody was named in the indictment as a YSL associate, not charged in the case. The interrogation video that shows him discussing the activities of YSL was previously leaked online, leading to scrutiny regarding his so-called snitching, raising concerns about witness intimidation against him. Pleads the fifth. On the stand, he's held in contempt, spends the weekend in jail, returns to court on Monday, agrees to testify, although he once again proved uncooperative. When prompted by a prosecutor to identify a defendant, he stalls and says he has a vision problem. Then he responded to other basic questions with similar stonewalling. Following the lunch break, Steele raised his concerns about how Copeland had been compelled to testify, calling it potential coercion and witness intimidation by the judge and prosecutors. To the order of the Glanville's order of contempt and incarceration, Steele wrote, in addition to the court's serious concern with how this information was improperly disclosed to defense counsel, Mr. Steele, this is Glanville's order of contempt and incarceration. He wrote, in addition to the court's serious concern with how this information was improperly disclosed to defense counsel, Mr. Steele made several claims regarding the sum and substance of the communication that the court found troubling. On Tuesday, Glanville scheduled a hearing for June 25th, so it's Tuesday, boys, today, for June 25th, in which he said those who were present for the private conversation, including Copeland and his lawyer, Copeland, who's Lil Woody, and his lawyer, will be made to explain why they, too, should not be held in contempt for disclosing information to Steele and the defense. After the contempt order, Colette Steele, a lawyer for Mr. Steele, who's also his wife and legal partner, immediately filed a notice of appeal as well as a motion to purge the ruling.
But I got this information.
I'm not going to have any further conversation with you about this. I want to know, the question still remains. I want to know who gave you the information?
I'd like to know what information happened outside our presence. That's really it.
He can go into custody at this point in time.
I think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny your motion. I'm going to deny your motion.
I understand that you spoke with a witness outside of our presence.
And whenever, yes, I had an ex parte conversation, which is appropriate.
And you influenced the witness based upon information belief, and I'd like to have that all on the record.
All right.
I mean, I don't know why that's so hard to do. If nothing happened bad, that's fine. But you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside of presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, that's for another day.
But why?
Okay?
Why
that's for another day.
In the first place, I didn't know about this stuff.
That's for another day. So
I raised it as soon as we found out about it.
Well,
I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2. That is a material or critical part of the case.
My
and
guy.
It's an automatic reversal.
Mr. Steele.
But you're acting like it's
Mr. Steele, that is not that is not the case when somebody discloses information in a ex parte conversation that one of the parties lawfully asked me to hold.
You're not supposed to have communication with a witness who's been sworn. You know, that I'm not telling you, I'm just saying if you read I'm assuming you read it. That's what it says. And you did it supposedly.
The state wishes to be heard.
You said it supposedly.
Yes, Your Honor.
And what I'm trying to get to is why did that happen outside of presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it. And then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6. And I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind anything.
And you can't hide behind, yeah, but the thing is, I think you got this information. Somebody disclosed it to you, and that's the only way you could have gotten it.
What I got.
Because unless you're sitting there.
Wow. I think you got this information from somebody disclosed this information to you. That's the only way you could have gotten it.
Unless you're sitting there, you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or that a party didn't give you the information. So,
Your Honor, but that's the issue, isn't it?
Well,
why aren't we
that leads to be told. But
right now, we don't know why we were excluded.
Okay. Anyway, this is
or who it was.
You've already said that. You've already.
And Your Honor, excuse me. And I know I said this previously.
Yes, sir.
But we are not accepting any proffer from this law.
Excuse me.
Okay. All right.
To the court. The court has inquired. We have no way of knowing what it is or who it was that disclosed information that was contained within an ex parte conversation. Not only was there an ex parte communication between that we requested as a state to be on record with the court, but there was communication made, I believe, to a person and his lawyer. I don't
Lil Woody
know that the reason that counsel took the podium was to address that particular issue so much as it was to try and assert an inaccurate what he calls fact and put it out there in the open as if it were true. But we certainly have the right to request ex parte communications. That's why we ask that the court reporter be present. This is a matter that the defendants did not have a right to be a part of, as this was a matter regarding a civil contempt that the court imposed upon a person for not obeying the court's directive.
Yeah, so she's trying to be like, the defense had no need to be there in the first place because this has nothing to do with the trial. Like, this doesn't have to do with Young Thug. This isn't something that evidence they need to be partial to. But the defense is making the point that this seems like witness coercion took place because the witness refused to testify and then was held in contempt, was jailed, and then this secret meeting took place, and then suddenly the witness changes their mind again. But the point being that, like, we as the defense need to be included in these things.
The state read the case that Mr. Steele cited. It does not stand for the proposition. He asserts that it does. And regarding further legal support for our position, we would provide that to the court, but we are more concerned that information that is disclosed in an ex parte setting gets relayed to the parties who were not privy to that. The whole purpose of the ex parte request was so that that did not happen. And we expressed on the record our concerns and our reasons for concern regarding that. We believe that without more information about how that information got relayed to the defendants, we cannot make the kind of assertion I'd be inclined to make. So before making the next set of assertions, I would need to know how that information was made privy to them, to counsels for the defendant. We did not act inappropriately or outside of the rules of professional responsibility. And if need be, we will reach out to the state bar ourselves and ask what the appropriate remedy is for everything that has happened over the last 2 days.
This is such a shit
last
show.
2 work days, because we are extremely concerned. We have observed a number of actions on the parts of a number of people that I am not comfortable stating publicly at this time, but that would appear to call for being addressed in some other way. So as to Mr. Steele's request, I guess it was for a mistrial. I'm not even certain what all that was. I think it was probably more to make inaccurate assertions on the record public to whomever was within listening shot of his voice. And we would ask that the court strike everything that he said from the time he stood up and started talking after the court asked him where it was that he obtained the information that was made privy in counsel for this court.
All right.
And regarding Rule 1.6, Your Honor, we read 1.6 as we're standing there. 1.6 in no way shields Mr. Steele's answer that the court requested he give. Rule 1.6 has to do with attorney-client privilege, and that is information that Mr. Steele obtained from his client regarding whatever matters. I don't know if the information was leaked to his client from someone who was in chambers, or if the information was leaked directly to Mr. Steele. In either event, it is concerning and in no way falls under the protections of Rule 1.6. If the court would allow me a moment.
All right.
When information is leaked.
Juncture by myself. I haven't found Mr. Steele in contempt. If the court continues in that position, that leaves Mr. Williams represented, at least at this juncture, by myself. That puts me in a position of making sure the court is aware that I'm in receipt of the same information that Mr. Steele received. I'm of the same opinion that the court is engaged in behavior that I believe compromises and corrupts the continuation of this trial. I do believe that we are entitled to and should receive a copy of the transcript so that a full investigation can be made as to what we believe has occurred here. And so I take the same position as Mr. Steele. I am asking for a mistrial, as he did previously, and I'm telling the court that I do not believe that we can proceed at this point based upon the information that we've received.
All right,
and frankly, I don't believe the state has any say in that. My statements are in regards to my representation of Mr. Williams, and if Mr. Steele is going to be held in contempt, I have exactly the same position. I also do not.
Well, I asked him, so I didn't ask you.
Yeah.
So, but
I think the judge specifically hates Steele.
I'll leave it at that. Okay.
That lawyer was like, I hold the same positions. If he's in contempt, I am representing Mr. Williams, and I too will. He couldn't even get out that he was trying to say that I too will not reveal the source.
What is it, Mr. Sharp?
Thank you, Your Honor. As you know, I represent Shannon Stillwell. On behalf of Shannon Stillwell, I am going to be moving for a mistrial, first and foremost. I just want to clear up a few things that have been said. Today, we were instructed to come 8:30 for a 9 o'clock start. I would not be honest with the court if I said I was here at 8:30, but I was probably here at about 8:40. We did not start till approximately, I'm estimating 11 o'clock. Clearly, we figured something was going on. We were given no...
You could literally clip that and apply that to apply that to Hassan's chat when they didn't start the basketball stream at 11 o'clock and instead started it at 12:15. Literally this.
At 8:30, but I was probably here at about 8:40. We did not start till approximately, I'm estimating 11 o'clock. Clearly, we figured something was going on. We were given no information about any meeting, who was meeting, what the meeting was about, or whether the meeting was ex parte or not ex parte, who requested the meeting, who was in the meeting. We were completely in the dark. And quite frankly, we kind of remain in the dark.
Yeah, new meme for whenever someone's late to stream. We were given no information.
I am not a false accuser, okay? I do not just willy-nilly accuse people of things. So, I'm not going to throw out spurious allegations like the ones that have been thrown at me over the past couple days that are absurd. But I will say, Your Honor, what I do know is just based on what we've heard over the last 20 minutes, it appears there was a meeting that I knew nothing about that involved Your Honor, the district attorneys, and a witness who had been sworn in. My client was not given an opportunity to be present at this critical stage. This was a critical stage in this trial. That error is a foundational structural error in this case, and it is the cause for an immediate mistrial. Additionally, Your Honor, I believe that this meeting, again, I'm going to ask for the transcript, and I'm going to ask for the recordings as well, should they exist. But I believe that this may have also, this meeting with a witness without us present may have made.
Also, there, of course, the defense team is going, or all the various defense lawyers here, they're going to climb on to this meeting because they are trying to do everything they can to get a mistrial. And this, so far, is the best grounds that they have for trying to do so.
The district attorneys and or Your Honor, a witness to this in this case, a material witness in this case. And finally, Your Honor, I'm going to ask for, as soon as possible, I'm going to ask that these proceedings be halted until we can obtain an accurate final transcript for what occurred where none of the defendants or defense counsel were present for. And also the recordings of that meeting so we can see where we are. Again, I'm not going to sit up here and make false accusations or spurious allegations. But I do think we need to figure out what happened. We need to be in the know and not in the dark about what happened when a meeting occurs with a witness that has been sworn in. And we're not invited to the party. So those are my requests, Your Honor. I think it's necessary at this time to put a halt to these proceedings. I am moving for a mistrial. I have not waived anything. I just found out about this information. It is timely, and that's our stance, Your Honor. Thank you.
I've noted your motion for mistrial. It's denied. Okay, I'll same thing. You want the Harvey? Okay, all right. Okay, Mr.
I'm adopting all of the statements.
All right.
Good afternoon, Your Honor. Carson Matthews.
All right.
Okay. We are also adopting.
Let's watch this, and then we'll move on to the other one. Oh, not that one.
Has been losing their damn minds over what happened yesterday at Young Thug's trial. The fact that he threw him in contempt is the least of this judge's problems, which is kind of crazy because that was also insane. There have been no clear explanations for people who aren't attorneys online for why exactly what happened yesterday is
Was the jury present for that? Yes, that's why the prosecutor asked for it to be stricken from the record.
Alone for this entire thing to be a mistrial. Why the judge is corrupt as hell, the prosecution's colluding, everyone is up in arms, but I'm gonna explain it to you now, okay? Amazing. This is Young Thug. His real name is Jeffrey Lamar Williams. He was arrested in November 2022, along with a bunch of other people on a slew of RICO charges, drug, gun, and gang-related charges. The prosecution's case is based on this theme. They're claiming that Young Thug and two other people co-founded a violent criminal street gang called Young Slime Life, YSL, and that it's associated with the National Bloods gang. They're claiming that he made the YSL name popular through his songs, etc., etc. No one cares. In one of the indictments against him, they're alleging that he committed 191 acts that essentially furthered this conspiracy to RICO the house and do all this gang activity, okay? One of those acts includes, which is important, includes the allegation that Young Thug rented a silver Infiniti sedan that was used in the killing of a rival gang member named Donovan Nut Thomas. This is Kenneth Copeland, one of the star witnesses for the prosecution. He was sworn in on Friday and was supposed to, because he has to do with the prosecution, testify in exchange for complete immunity. Okay, when that happens, you can't just plead the fifth and have your cake and eat it too. Okay, you do need to testify. And on Friday, he was pleading the fifth, okay, the whole time. So he was held in contempt over the weekend, but by Monday, he appeared to have a change of heart. During his testimony, take a short lunch break at court. After the lunch break, Brian Steele, Young Thug's attorney, stands up and is like, "We just learned something over lunch. What in the hell?" As this tweet summarizes, Brian Steele stands up and says, "Hi, Judge Glanville. I learned over the lunch break from someone that there was an ex parte meeting," and I'll teach you what that means, okay, between you, the judge, the prosecutor, the sworn witness, and the witness's attorney, without any of the defense attorneys present or notified about it. That is not allowed. Ex parte communications are communications that a judge has with one party's attorney or party and not the other one, okay? They're seen as the biggest no-no. That's why we have it in writing. This is Georgia's Judicial Code of Conduct, okay? Ex parte communications, right? You say here, judges shall not, no chance, initiate, permit, or consider ex parte communications or consider other communications made to them outside the presence of the parties or their lawyers concerning a pending proceeding or impending matter. Doesn't that sound like this? Yes, it does, okay? Even no matter what was said in the chambers, which I'll get to, which is crazy, even if they just talked about their Jimmy John's order, all right, in chambers, still beyond not okay, and grounds for a mistrial, arguably, all right? Judge Glanville did not notify any of the defense attorneys.
Yeah, you know, the thing about the law is, I mean, this goes for both defense and prosecutors, but they will just say whatever their interpretation of it is as to how it benefits them. Like when the prosecutor said, we specifically asked for, for an ex parte because that means that the defense is not, needed in this meeting. Like, we followed everything by the book. That's what the prosecution is arguing. We followed everything by the book, and because this was ex parte, the defense had no right to be there.
He didn't do any of this, and he didn't invite them to the conversation because, duh, if they would have been invited, they would have objected to it. They apparently had a conversation in his chambers that morning that somehow led to the witness now testifying.
He used to submit ex parte stuff all the time to courts and notify opposing counsel to not do so would have to be intentional. It's so fundamental.
And Brian Steele says, and confronts the judge with, he learned that during that meeting that they weren't invited to, which is not allowed, the judge, after the witness basically says, yeah, I'm not testifying, hold me for 2 years, whatever, the judge tells him, well, I can hold you, if you don't testify, in jail for as long as I want until these other 26 defendants already have their cases tried. Basically coercing, intimidating the witness to testify. The judge. And it gets worse. Apparently during that meeting, the witness confessed to being the one to murder Nut, a rival gang member who Young Thug is accused of renting a car in order to help in his murder, whatever. That is exculpatory Brady evidence, what we call it, okay? That confession is evidence that tends to prove the innocence of Young Thug in that scenario. And again, it has to be disclosed under the law. To the defense attorneys, it was not disclosed. There are layers to the corruption and tomfoolery going on here. In response, as any clearly innocent person does, judge doesn't deny that that happened. He just yells at him and says, how did you get your information? Who's your source? I'm very concerned.
And you haven't answered my question yet.
I'm not going to answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate. I'm not trying to get anybody else.
I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based upon information.
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have this. I have problems right now.
Okay, I know. Look, I don't want to know about your problems. Okay, at this point in time, all I'm asking you at this point in time is, how did you come upon this information? Look.
Imagine you're accused of something as serious as witness tampering in an active pending trial. And your response isn't to deny the allegations, it is to badger the attorney about who his source is. And in doing so, throughout, you can watch the video, it's very clear that he's hinting at the fact that, yeah, all that did for sure happen.
Yeah, it also seems pretty bad that a judge can just throw a lawyer in jail if they fail to answer every question that they ask them. Like, that shouldn't be able to be wielded as a weapon. And it looks especially bad in this situation because clearly the judge is clearly the judge is power tripping here and is coming across as very partial to the prosecution.
Brian Steele refuses to tell him. Of course he does. Brian Steele says, this is a violation of my client's constitutional rights because he has a constitutional right to be there for every phase of the trial and he wasn't there in that back room, so that's a violation. So many rules being broken here, it's not even funny. So Judge Glanville has no grounds to force Brian Steele to tell him who the source is, but that's what he's sticking on. Pursuant to Rule 1.6 of the Rules of Professional Conduct, which is what all of us attorneys are bound to follow, okay, we have to. Everything you learn through the course of your representation of a client is confidential, meaning you cannot disclose it without a court order subpoena. It's not a thing, okay? It's not a thing. The court cannot just say, the judge cannot just say, you tell me who your source is, and I have to tell you who the source is, pursuant to, basic ethics, but also, let's get to the root of the problem here. The source doesn't fucking matter when the information is correct. You can find all of the crazy quotes by this man, okay, during this exchange. He just keeps saying, you need to tell me, or I'm going to put you in contempt, and he's like, no, I'll let you have 5 minutes to think about it before I hold you in contempt. And he's like, I don't need 5 minutes, actually. I'm not telling you. There are two different types of contempt, civil contempt and criminal contempt. They're different, not based on, it's a criminal trial, so it must be criminal. No, it's based on the purpose of the contempt order. Civil contempt is where you are trying to coerce compliance with a court order. Criminal contempt is to punish conduct, okay, like something that happened in the courtroom. Summary, criminal contempt in that sense, but it's a crime, okay? So you are afforded all of the due process rights that anyone accused of a crime are afforded, and it has to be proven beyond a reasonable doubt. This buffoon of a judge, pardon my French, doesn't know the difference between any of the contempts, and no one apparently told him on Google when he clearly Googled it during his 5-minute break. That was 2 hours, okay? He just keeps repeating, this is criminal contempt, this is summary criminal contempt.
In most situations, I'd be like, who amongst us has not Googled our job while we are at work? But this is a situation that is pretty terrifying to have a judge overseeing one of the most complex RICO cases in history, Googling his job on the job. And it's also a reminder, y'all, that voting isn't, like, as far as voting being important, it's not just voting for federal candidates. It's not just voting for the president of the United States. These elections are also important.
Everyone's like, no, it is not. It's literally not, because you're saying that he can get out of jail if he tells you what the name of his source is. So that would be civil contempt because you're trying to coerce compliance with a court order, which has to be lawful in the first place. And this isn't really a court order. It's just him yelling at him about something. You get it. Criminal contempt is where you are punishing behavior, okay? So he has to be disrupting or preventing justice from happening in the courtroom. If anything, he's the only one trying to have it happen. Fuck. So he is arrested, okay? Put into jail. Immediately, 25 defense attorneys, okay? And
By the way, his His term ends December 31st this year. So hopefully there is he is not reelected.
President of the Georgia bar, defense attorney bar, I'm sorry if I'm saying that wrong, comes in, okay? Her name is Ashley Merchant, and she comes in his defense, like to represent him. And she hands the judge's ass to him in a very professional, correct way, and basically explains the difference between civil contempt and criminal contempt to him, the importance between the two, and says he's entitled to a hearing, okay? Notice, opportunity to be heard, counsel, all of that. And he says, no, he's not. No, this is sua sponte criminal contempt. He doesn't have a right to appeal this. No, he won't get a written order. Buzzer. Wrong. He is entitled to appeal it. He is entitled to a written order, a very specific written order. There's so many things. Essentially, the summary of it is he's sentenced to 20 days on the weekends to serve in jail, okay, for criminal contempt. And he asked, can I serve it with my client in the same cell as him, as Young Thug, so that we can prepare our
Yeah, he was
case?
reelected on
And the
May
judge said,
21st.
Sure. And as he's being led in cuffs out of the courtroom, he's making all these motions. He did everything he possibly could and was such a G about it. And the moment, like the millisecond that the judge, okay, issued his shitty, horribly written bullshit order of contempt that has no foundation in law or logic, his wife, Colette's...
I must be confused. Do people actually want Young Thug to get off on these charges if he is guilty? Like, we don't care if he did do these crimes? No, that's not what's going on here. We're talking about a couple issues at play. One being the use of lyrics and the use of social media, like what they're wearing in photos and gang signs that they're throwing up in pictures being used as evidence to convict them of these crimes. And we look at the standard of rap being the only genre of music where the lyrics and of the music have historically been used in criminal trials. And then also how very clearly unconstitutional this entire thing is that we've been covering for the past 45 minutes. It's about it's about ensuring that the legal system is not being utilized to unfairly fuck over Young Thug and the other co-defendants. And it's about making sure that this is not then further setting a precedent for future use of, I mean, not that this is like the first time it's been used, but for future use of this type of evidence being used in criminal trials.
Steele is representing him because they're both attorneys on his appeal, immediately files the notice of appeal. It's not appealable. We just did. And today they have just continued the witness's testimony and continued trial as if nothing has happened. So appeal's going to go through hopefully quickly. I want to fly to Georgia and shake Brian Steele's hand and all of those attorneys who pulled up to the courthouse in support of Brian Steele. They are a crew and they protect their own, and they're not going to let this shit happen to Brian Steele without a fight. I'm proud to be an attorney on this side, and I hope that Judge Glanville gets what he deserves.
Moxie Furiosa, thank you for the 2 months. God, I can't get over where was, let me pull up one of the examples. Hold on. Oops. Not that. Was it in here? There was one example of like one of the lyrics was, "I give my lawyer $2 million, and he covers up the bodies," or something. It was. Obviously that's not the exact lyric, but that was another example of the lyrics that they have used in the trial so far. Of like, see, evidence. Were those bars? I give my lawyer $2 million and he covers up the bodies. Yeah, I got bars. If you want to see more on what has happened previously in the trial, a DA investigator harassed a witness because he wanted to date her. He didn't show up out of fear, something that was casually looked over. Oh yeah, I think I mentioned this in the article that I was reading. State witness from yesterday testifies that she was sexually harassed by the state's investigator and is afraid of the state. She said that's the reason that she refused to show up to court before the state had her arrested. Man, Thugger Daily is really on this case. Wanted to share this lighthearted moment in court of Keith Adams getting everyone, including the witness, to laugh out loud before we get to the more serious stuff.
You recall that I came back there with Mr. Steele, gentleman back there with the grayish white hair, Mr. Matthews, this gentleman right here with the very gray hair, right, and Miss Westmoreland. Yeah.
I'll sustain that objection.
At least you got here. And Miss, okay. You recall that I came back there.
Keith Adams starts the morning by addressing the state's question from yesterday. Are you afraid of Jeffrey Williams? The witness says she has no reason to be afraid of Thug. She says instead she was actually on edge and afraid of the state.
You at one point. Are you afraid of Jeffrey Williams? You remember that question?
Yes.
And she may not have said Jeffrey Williams. She may have said, are you afraid of Thug? You remember that?
Yes.
Okay. And your answer was no. Is that right?
Yes.
You have no reason and had no reason to be afraid of Jeffrey Williams. Is that right?
No, I don't.
Okay. In fact, when you testified yesterday, you were on edge. Is that fair to say?
Yes.
You didn't want to be here.
Yes.
And part of it is because of the interactions, and your reaction yesterday was based on the interactions you had, not with Mr. Williams or anyone over here, but with the district attorney's office. Isn't that true?
Yes.
Fashan joining YSL thinking she was being hired as a model for Yves Saint Laurent. She says it felt like the state's investigator Mr. Hamilton was trying to date her.
Mr. Hamilton had harassed you. Is that correct?
Yes.
In fact, you told us when you were back there that you didn't want to come out and see him because he had sexually harassed you. True?
Yes.
You felt like, and you told us, that you were really concerned about coming out here.
I'm going to object as to relevance.
I'm overruling the objection.
You told us that the times when he would contact you, it seemed like he was trying to date you.
Yes.
In your interaction with, and then Mr. Hamilton, you actually met with him at different locations. Is that right?
Yes, I met him at a restaurant.
Japanese restaurant off of Moreland Avenue?
Yes.
A couple months ago?
Maybe, I think February.
Okay. He wanted to meet you, supposedly to talk about the case.
Yes.
But he wanted to meet you by yourself.
Yes.
You did not feel comfortable with the interactions you've been having with the district attorney's office, and so you brought your 20-year-old son along with you.
Yeah.
Jesus. She says the state's investigator said he would love to take her out when this is all over. The state's investigator also told her not to talk to anyone else at all about the case. She says she lost her job due to how many times the state's investigator asked her to meet with him. Mr. Hamilton told her, "Don't worry, I'll get you a job." Geez. Just to reiterate, I think I think if you're in chat and you are like the way that you're looking at this whole thing is a matter of like it's just simply a matter of like putting a criminal away if they did the crimes and not thinking about like the legal system being wielded unjustly to put someone away and for bad legal precedents being set. Like if you're not concerned at all with how the conviction is brought, on what grounds, with what evidence, then that's something that like you need to sit and think about that. It's not just did this person commit the crime and therefore should do the time. It's how the person is convicted for the crime that they've been charged with. And just imagine if it was you. Exactly. Imagine if it was you and you were caught up in a legal situation like this. You would pray and hope and also expect that your due process is being met, that there's not evidence being wielded against you that is that is a violation of your rights to free speech. The legal system abuses and takes advantage of people. If you want the system to convict people, it should be done clean and accurate. People have this thing where they only want the law to work for people they perceive as innocent. Right. A lot of people have already made up their minds as to the guilt of a defendant and therefore don't believe that anything that happens in between is important. If the defendants are guilty, it's even more important that the prosecution is above board, because anything else would mean they can be released on technicalities. Yeah, and if this shit goes on, that is a point that I meant to make. If this shit goes on, when we are talking about someone who is famous, who is a multimillionaire, who can afford the best legal team, whose trial is being live streamed, and because of not only the complexities and the vastness of this trial, but also that the defendant is Young Thug, a famous rapper, means that every journalist is reporting on this. Like, this is being covered by news outlets galore. Now imagine if none of that stuff, which is most of the time, none of that stuff is there. And think about what happens during those trials, like how those defendants are screwed over and abused by the legal system. And that's why I said, never mind. All right, I got to move on. I got to move on. I wanted to cover some of this next, this other trial before I get to Yarn and the Minecraft. Anywho, now that I'm tuned into this trial, we will cover updates. It's going to go on for a very long time. It is giving clown show. It is giving circus. It is giving mess.